Hello viewers and welcome to AIL TV. I am here to talk about insolvency law, specifically personal insolvency law, because we do know that there are a lot of people out there who are dealing with debt problems. My name is Primerose Chiguri. I'm a solicitor and I will be back with more information for you. So, insolvency law. What are we talking about? We are talking about a situation where a person is in debt and they cannot afford to pay their debt. You might have one creditor or more creditors who are coming up against you and threatening to make you bankrupt if you do not pay. So today we want to talk about that particular scenario. You have received demands and you've not been able to meet the demands to pay back the debt. You have options. Instead of burying your head in the sand, you can actually oppose a bankruptcy petition if your creditors decide that they would like to apply for a bankruptcy order to be issued against you under the Insolvency Act of 1986. It is not as daunting as it seems. A lot of people just decide to bury their heads in the sand when they get the demand letters for them to pay and they hope that it will go away. But most of the times it does not go away. The creditors can be persistent enough to ensure that you get a bankruptcy order made against you. It is important to note that having a bankruptcy order issued against you is a very serious matter that can have potentially serious consequences depending on your personal circumstances. If you have a home, you might lose your home. If you are in business, that might make it very difficult for you to run your business because you might not be able to operate a bank account whilst you have a bankruptcy order issued against you. Even if you don't have a business, you might still not be able to operate a bank account if you have a bankruptcy order issued against you. It might also affect your credit history. It might also affect your employment, depending on what sort of employment you are looking for. And it takes 6 years for someone to be discharged from the bankruptcy order. So 6 years is a long time. It is actually better to take steps to prevent getting to that stage whereby you have that bankruptcy order. And it is worth making the effort to fight the bankruptcy petition in the courts. There are many grounds for challenging an application for a bankruptcy order to be issued against somebody who owes money. Normally, creditors will normally seek a bankruptcy order if you owe more than £5,000. So if you are in that situation and you have been trying to resolve the matter with your creditors and you've made reasonable offers to your creditors, but they've turned that offer down, that in itself might be a ground for challenging their application for a bankruptcy order. There are many other grounds on which you can challenge an application for a bankruptcy order where your creditors decide to go ahead and apply for one in any event. Obviously, we do not have time on this program to go into detail about all the grounds. I've just given you the one ground that you can rely on. That's if you've put forward a reasonable offer to pay and the creditors have refused to accept that offer. It is something that you can rely on to challenge their application to make you bankrupt. We are here to help you if you are in a situation where you do not know what to do with your debts. But it is important to note that if you have creditors come against you, you need to take action. You need to seek legal advice at the earliest available opportunity. Normally, before it even gets to a stage where your creditors will put in a bankruptcy petition application, they will have written to you several times, or they would have sent you a statutory demand. If you do receive that statutory demand, it is at that time that ideally you should seek a lawyer if you are struggling with getting the matter resolved with the creditors. Do not wait any longer because there are time limits as to when you can challenge bankruptcy petition proceedings or when you can challenge the creditors after they've served you with a statutory demand. So it is important to just speak to a professional, an insolvency practitioner, a solicitor, who can give you advice on your options so that you prevent having a bankruptcy order issued against you. But if you are in a situation where you're already dealing with an order that's already been issued, you didn't take action when you were notified of the proceedings, all hope is not lost. Still seek advice, because you might be able to apply to have the bankruptcy order set aside. So if you are in a situation where you think, oh, I already have it, they've already issued the bankruptcy order, that is not the end of the matter. If you're not happy about it, do seek legal advice and check the grounds on which you can challenge the order or seek to have the order set aside. Okay, we do not have much time, but for today we will end here. If you'd like to know more about insolvency law and how you can resolve your debt issues, do contact us on the details that are appearing on the screen right now. As I said, my name is Primrose. I'm a solicitor and I have experience with dealing with debt matters, and I'll be very happy to advise you and assist you in your case. Stay tuned in to AIL TV for more future programs on legal matters. We'll be discussing different legal matters that we feel are relevant to our viewers. Thank you for tuning in. Goodbye.